Good afternoon and welcome to McGuire-Woods SEC Compliance and Disclosure Update. I'm Jay Anderson, a partner in the firm's Securities and Capital Markets Department and the moderator for today's program. McGuire-Woods is a full-service law firm with more than 1,100 attorneys in 21 worldwide offices. Our more than 50 securities and capital markets lawyers represent some of the nation's largest business and financial institutions. We regularly serve as counsel in public and private securities offerings and help clients understand and address unique securities compliance issues and reporting requirements. Recently named Banking and Finance Law Firm of the Year by Law 360, McGuire-Woods consistently ranks among the top law firms for representing clients in capital markets transactions. I also want to note that today's presentation is entirely about the current COVID-19 environment and the securities law implications of the pandemic. I want to note that many of our presenters today have put out client alerts and thought pieces regarding many of the securities law implications of coronavirus. Further, our firm puts out COVID-19 alerts nearly daily on a wide range of legal topics, as well as a summary at the end of each week on developments with various links to our alerts. If you don't already receive these alerts, please feel free to sign up for them at McGuireWoods.com or ask your McGuire-Woods contact attorney to sign you up. Before we begin today's program, I'd like to call your attention to the Q&A icon in the lower left-hand corner of your screen. Please use this widget to submit any questions you may have to our panelists at any time during the program. We will do our best to address your questions in the time allotted, but if we're unable to do so, we'll follow up with you by email. You'll also find a number of additional resources along the bottom of your screen, which we encourage you to explore during today's presentation. Notably, the meeting materials folder includes a copy of today's presentation slides. So without further ado, let me introduce our first speakers, Rakesh and Daniel. Based in our Charlotte office, Rakesh is a partner in our Securities and Capital Markets Group and co-chair of the firm's FinTech practice. He regularly handles public company security issuances and reporting requirements, private and public company mergers and acquisitions, and other corporate and transactional matters. Daniel is an associate in our Richmond office and focuses his practice on securities and other corporate transactional matters. They will be discussing the COVID-19 disclosure impact on earnings and 34 Act filings. Rakesh and Daniel.
Thank you, Jay. And thanks everyone for listening. I hope you all are staying safe and healthy in these uncertain times. This morning, Rakesh and I are going to be discussing the SEC's guidance to companies with respect to their disclosure obligations in periodic reports and earnings releases, how companies responded in their first quarter, and what companies should consider going forward in the next quarter. As you might imagine, providing accurate and timely disclosures has never been more important to the investing public and the SEC, and it has rarely been as challenging for companies as they, like all of us, seek to understand the full impact of the global COVID-19 pandemic. Before I get into the specifics of the SEC guidance, I have a few introductory remarks on the SEC's guidance. First, as you can see from this timeline, Chairman Clayton, the SEC staff, and the Division of Corporation Finance have all been issuing guidance periodically since the COVID-19 crisis began, and the guidance has gotten more specific as the full impact of the pandemic has come into closer focus. In addition, the guidance has not been issued in sweeping releases or pronouncements, but rather has come from a variety of sources: the SEC staff, the Division of Corporation Finance, and the Chairman of the SEC, and has come in various levels of formality: joint statements, frequently asked questions, and published disclosure guidance. It should be noted that the guidance reflects a tension between the SEC trying to give companies flexibility in responding to the rapidly evolving COVID-19 crisis, while ensuring that investors have access to accurate disclosures and financial guidance. Finally, I want to point out that the SEC staff has issued additional guidance regarding municipal securities, broker-dealers, investment companies, and investment advisors, but this guidance is beyond the scope of this presentation. In March 2020, the Division of Corporation Finance published CF Disclosure Guidance Topic Number 9, which discussed the division's views on how companies should disclose the impacts of the market disruptions caused by COVID-19. Although this guidance was initially released prior to when most calendar year companies would be drafting their first quarter 10-Qs and providing earnings guidance for the first quarter, the lessons from this topic are still important for all public companies going forward. In disclosure guidance topic number 9, the division began by noting that, although the impact of COVID-19 is developing in real time and leading to uncertainty, functioning markets require timely, robust, and complete information about how the pandemic will impact companies. Even though timely reporting may be more difficult due to the exigencies brought on by the coronavirus, and even though it will be difficult for many companies to assess or predict with precision the broad effects of COVID-19 on industries or individual companies, companies should consider the need for COVID-19 related disclosures within the context of federal security laws and its principles-based disclosure system. The division further noted that the cornerstone of the disclosure system is that material information be widely disseminated to market participants so that investors can make informed decisions. The division then discussed how companies should assess and disclose the evolving impact of COVID-19 and how management plans to respond to challenges presented by COVID-19. Whether or not to make disclosures of COVID-19 is, the division noted, a facts and circumstances analysis, and the disclosures made should be specific to a particular company's situation. To aid companies in determining whether any such disclosure should be made, the division provided a list of questions and examples to consider, but noted that any such disclosure should be tailored and provide material information about the impact of COVID-19 on the company to investors and market participants. Some of the questions provided by the division included: how has COVID-19 impacted the company's financial condition and results of operations? In light of changing trends in the overall economic outlook, does the company expect the pandemic to impact future operating results and near and long-term financial condition? Will future operations be impacted differently than operations in the current period? In addition, what impact has COVID-19 had on the company's capital and financial resources, including the overall liquidity position and outlook of the company? Has the cost of or access to capital funding sources, like revolving credit facilities, changed or is reasonably likely to change? Will the company be able to meet its covenants and its debt agreements or its credit agreements? Are there any known trends and uncertainties in the company's ability to service its debt or other financial obligations, access the debt markets, including commercial paper and other short-term financial arrangements, changes in the valuation of collateral, and any change in counterparty or customer risk? How will COVID-19 affect assets on a company's balance sheet and the company's ability to timely account for those assets? For example, will there be significant changes in judgments in determining the fair value of assets? Will the company's ability to maintain operations, such as financial reporting systems, internal controls and financial reporting, and disclosure controls and procedures, be impacted by, for example, remote work arrangements? Does the company expect COVID-19 to materially affect the demand for its products or services, or will there be a material adverse impact on the company's supply chain or the methods used to distribute its products or services? And how has the company experienced challenges in implementing business continuity plans? Will operations be materially impacted by any constraints or impacts on human capital resources or productivity, or will travel restrictions and border closures have a material impact on a company's ability to operate and achieve its business goals? Those are just some of the items that the division encouraged companies to consider in determining whether COVID-19 related disclosure might be appropriate. The division continued that it was encouraging companies to provide disclosures that would allow investors to evaluate any current and expected impacts of COVID-19 through the eyes of management. These disclosures, the division stated, should be revised and updated periodically as the underlying facts and circumstances change. Finally, the division reminded companies that when they provide forward-looking information regarding material developments and known trends and uncertainties, they may rely on the safe harbors for forward-looking statements in Section 27A of the Securities Act and 21E of the Exchange Act. In addition to the guidance regarding COVID-19 disclosures, the division's topic number 9 addressed several other COVID-19 related issues. First, the division reminded companies and other persons to consider their market activities, including the issuance or purchase of securities, in light of other federal securities law obligations. For example, if COVID-19 has impacted a company in a way that would be material to investors, or where a company has become aware of a COVID-19 risk that would be material to investors, the company, its directors, and officers and other corporate insiders who are aware of these matters should refrain from trading in the company's securities until such information has been properly disclosed to the public. Companies should also take steps to avoid selective disclosure by disseminating any material information broadly to the public. The division also addressed some concerns companies might have in releasing their earnings estimates or other financial results given the challenges of the pandemic. The division noted that the impact of COVID-19 may present novel or complex accounting issues that could take time to resolve, or that companies and their auditors may need to consult experts to determine the impact of COVID-19 on a company's assets, such as the impairment of goodwill or other assets. Ultimately, the division did not tell companies how to accommodate these changes, but advised issuers to proactively address financial reporting matters earlier than usual. With respect to companies that wish to use non-GAAP financial measures in their earnings guidance, the division reminded companies of their obligations to present and reconcile non-GAAP financial measures. To the extent a company chooses to present a non-GAAP financial measure or performance metric to adjust for or explain the impact of COVID-19, the division stated that it would be appropriate to highlight why management finds such measure or metric useful and how it helps investors assess the impact of COVID-19 on the company's financial position and results of operations. The division also advised that where a GAAP financial measure is not available at the time of the earnings release because the measure may be impacted by a COVID-19 related adjustment that requires additional time and analysis to complete, the division would not object to companies reconciling a non-GAAP financial measure to preliminary GAAP measure results that either A, include the provisional amounts based on a reasonable estimate, or B, include a range of reasonably estimable GAAP results. In addition to the division's topic number 9, the most significant pronouncement on COVID-19 related disclosures and financial reports was a joint public statement by SEC Chairman Clayton and the Division of Corporation Finance's Director Hinman entitled "The Importance of Disclosure for Investors, Markets, and Our Fight Against COVID-19." In their remarks, Chair Clayton and Director Hinman began by noting that the country's collective mitigation responses to COVID-19 has resulted in a sharp contraction in many aspects of the economy and increased volatility and uncertainty in capital markets. They continued that there is intense investor interest in company-specific operational and financial status and plans for addressing the effects of COVID-19. Specifically, investors and analysts are anxious to know where companies stand today and how they have adjusted and expect to adjust in the future their operational and financial affairs to work effectively through the pandemic. Most importantly, the pair noted that robust, forward-looking disclosures about COVID-19 will benefit investors, companies, and more generally the global fight against COVID-19 by facilitating communication and coordination among the public and private sectors. To accomplish these goals, Chair Clayton and Director Hinman requested that companies provide as much information as is practicable regarding their current status and their plans for addressing the ongoing effects of COVID-19. In particular, Chair Clayton and Director Hinman requested that companies, 1, provide detailed discussions of current liquidity positions and expected financial resource needs, and 2, provide a discussion of the impact of company actions to protect worker health and well-being and customer safety. With respect to companies taking advantage of government financial assistance under the CARES Act or similar COVID-19 related federal and state programs, Chair Clayton and Director Hinman advised such companies to disclose how such assistance has materially affected or is reasonably likely to have a material effect on a company's financial condition and results of operations. Companies so affected should disclose the nature, amounts, and effects of any such assistance. Chair Clayton and Director Hinman concluded their statement by noting that the SEC remains committed to investor protection and market integrity and will identify any bad actors who would try to use the current crisis to prey on investors. To that end, the pair advised companies to carefully protect and distribute any material, non-public information regarding the COVID-19 crisis, including by making sure such information is closely held until disclosed and, if disclosed, is broadly disseminated. Chair Clayton and Director Hinman echoed the disclosure guidance topic number 9 discussed previously by reminding companies that they can still take advantage of safe harbors for forward-looking information in both the Securities Act and Exchange Act. Thank you all, and now I'll turn things over to Rakesh to discuss lessons learned from the first quarter and how companies should approach disclosures in the second quarter.
Thanks, Daniel. So wanted to talk through some of the observations that we had on the first quarter 10-Qs and other filings that have been made by the calendar year companies, as well as things to look forward to as you think about your second quarter. So as it relates to what happened with respect to first quarter earnings and 10-Q, clearly many companies were grappling with what to do with their existing annual or quarterly guidance that were issued pre-crisis. Generally speaking, there's no affirmative duty to update earnings guidance. Those statements, as Daniel's mentioned, are covered by forward-looking statements, safe harbor, and other regulatory provisions. However, of course, that analysis always does change if the company is in the market, conducting an offering, things of that nature. In addition, companies may have a difficult time speaking candidly with analysts and investors from a Reg FD perspective or general securities disclosure perspective, in light of sort of if there's a radical shift in expectations. You have anytime there's a mismatch between what's potentially materially non-public information held by the insider or the executive and the other person with whom they're speaking, it creates challenging and difficult situations, and it's very difficult to have set the proper expectations on the street, clearly with such changed circumstances. So as a result, a lot of companies chose to simply withdraw guidance and remain silent until there was more stability. And clearly, you saw a lot of that in the late March timeframe, when it wasn't even possible for many companies to get their hands around what exactly would the impact would be, and how to quantify it. Recently, you're seeing companies going back and providing updated guidance, or even rather than a full remainder of the year guidance, more of a quarterly or smaller, shorter snapshot guidance, and in some cases different metrics than they had previously disclosed, just in light of what is reasonable, what is reasonable in terms of forecasting. In the actual filings themselves, risk factors were definitely a hot topic. Generally, in your 10-Q, as you might know, you would only update or add a risk factor to the extent that the 10-K risk factors had materially changed. And companies often chose to include a specific COVID-19 related risk factor. And, I would say that was probably the recommended best practice, rather than relying on general risk factors that were often in 10-Ks and have been in 10-Ks for a while, even those that relate to force majeure and those that mention the word pandemic specifically, just because of the specific knowledge of this drastic circumstance. And the risk factors themselves came in a variety of forms, which are highly specific to the individual company and the industry, and listed on the slide some of those examples. The other lessons that we've learned from first quarter reports, is that the disclosure impact of COVID-19 is definitely infused throughout, and not limited to risk factors, as you might expect, due to the fact that the impact was so comprehensive. So you saw some specific areas addressed, like non-GAAP exclusions, additional paragraphs sometimes in MD&A, including sometimes in the first few paragraphs or in the very first sentence. 8K disclosures, obviously is outside of an 8K context, but to the extent that the impact created a material impairment or other 8K triggering factors, you saw sometimes 8K triggers, 8K disclosures. Forward-looking statements, disclaimers were updated. Again, going back to the concept that the SEC wants specific impacts of not just COVID-19, but any forward-looking statements, rather than just relying on boilerplate and having it, the same from year to year without thoughtful consideration as to how those factors might impact your company in a given time period. In addition, financial statements, footnotes, and accounting matters, and internal controls over financial reporting. Although I will note that, at least in my experience, many companies were able to shift to a virtual finance and accounting environment, certainly easier in some cases than physical and manufacturing aspects of a company. And those companies often took the position that none of their workflows, processes, or controls were materially affected by the crisis. So as long as they were to have the same level of accounting entries, supervision, oversight, escalation, and communications with their auditors and things of that nature, the question was raised as to whether there were any material changes in their internal control framework for purposes of disclosure in the 10Q, and I found that a lot of companies determined that there was no material change. Next slide. Thank you. Looking ahead to the second quarter, there's not much that you wouldn't actually, if you go back to slide 13, sorry about that. There's not a whole lot that you wouldn't expect, which is continued focus on the specific impacts of COVID-19. So if you hadn't had a specific risk factor included in your prior filing, think about the extent to which that might be appropriate. If you did, think about any specific material important impacts that the crisis is having on your company, maybe as opposed to other companies. Now that companies are getting a clearer sense on the impact, we're starting to see companies go back and provide the sort of more limited guidance. So think about that and how to carefully message that appropriately, and also rely on the appropriate protections of the safe harbors. Make sure you're carefully managing non-GAAP financial measures. We would imagine that a lot of the non-GAAP measures would exclude sort of the impacts of the crisis. So make sure you're disclosing that, thinking about it properly, and using the right terminology, and that gets you a file of non-GAAP language. And continue to coordinate with your finance and accounting team, particularly as it relates to goodwill impairments and other 8K trigger items. As things become more concrete, the accountants might have to retest goodwill, and there are some implications on those items as it relates to 8K items and other 10Q disclosure items. All right, thanks.
Thanks, Rakesh and Daniel. Our next presenter is Barlow Mann. Barlow is a Securities and Capital Markets Associate in our Charlotte office. He focuses his practice on representing public and private companies in securities transactions and other general corporate matters. He will discuss disclosure and due diligence considerations for securities offerings in the current COVID-19 environment. Barlow?
Thank you, Jay. Okay, so Rakesh and Daniel provided an excellent overview of the issues that are raised by the COVID-19 pandemic in connection with the company's 34 Act filings. This presentation will focus more directly on analyzing these issues in connection with the securities offering. The difference here, or the reason that an issuer might focus more closely on COVID-19 in the middle of a reporting cycle, is of course that the issuer is taking Section 11 liability in the case of an SEC registered offering, or 10b-5 liability in connection with its disclosure document in connection with an offering. And the underwriters or initial purchasers in connection with that offering will also have a due diligence process in order to satisfy themselves with their position with respect to potential liability in connection with the offering. It may be tempting for an issuer to think that because it included a COVID-19 risk factor in its most recent 34 Act filing, along with a paragraph in its MD&A regarding the potential effects of the pandemic, it won't need to think about COVID-19 if it wants to go to the capital markets later in the quarter. Depending on the disclosure that the issuer actually provided and its sensitivity to pandemic-related issues, that may or may not be the case. I will start by describing a general framework for thinking about these issues, then discuss due diligence, disclosure, and some related issues around closing the deal. In this presentation, I will focus on issues that will be important to consider in all securities offerings, without focusing too much on distinctions between SEC-registered offerings versus Rule 144A and Reg S offerings, or between offerings of debt versus equity. However, the presentation generally is aimed at companies that are SEC reporting issuers. Moreover, I would note that for the general reason that questions of materiality tend to be more difficult in an equity offering than a senior debt offering, the stakes likely will be higher and the analysis will be more sensitive for an equity offering as compared to a debt offering for the same company. Overall, thinking about disclosure and due diligence for a securities offering during this time involves applying tried and true disclosure principles, but the sensitivity is heightened by the speed with which material developments may occur in the current operating environment. So, going back to the disclosure basics, this slide includes quotations from Rule 10b-5 and the SEC's 2003 interpretive guidance regarding management's discussion and analysis. With respect to Rule 10b-5, I will discuss this in greater detail later on, but for now I will note that in the current environment, issuers may face thornier issues around the second prong of this rule, omission to state a material fact necessary in order to make the statements made in light of the circumstances under which they were made not misleading, rather than affirmative misstatements. This is because of material facts that may develop during the quarter that were not previously disclosed. With respect to the SEC's 2003 MD&A guidance, although as a technical matter, this interpretation applies when a company is preparing MD&A disclosure in response to Regulation SK Item 103, for example, in a Form 10K or 10Q, the SEC's position regarding the requirement to disclose known material trends or uncertainties is often viewed as a guiding principle for assessing whether a particular development with respect to a company is material and should be disclosed. Note that the SEC's guidance here breaks down into two components. First is the known trend, demand, commitment, event, or uncertainty likely to come to fruition. Second, if management cannot make that determination, it must evaluate objectively the consequences of the known trend, demand, commitment, event, or uncertainty on the assumption that it will come to fruition. Disclosure is then required unless management determines that a material effect on the registrant's financial condition or results of operations is not reasonably likely to occur. This slide offers one high-level framework for thinking about the due diligence and disclosure process in connection with the securities offering during the COVID-19 pandemic. There are obviously many ways to think about this topic. However, two of the main factors to consider are, first, the relevant issuer's particular sensitivity to COVID-19, and second, the timing of the offering within the issuer's reporting cycle. With respect to issuer-specific sensitivity, for some companies, the effect of the pandemic may require day-to-day analysis of whether the issuer's disclosure is sufficient. For others, the analysis may be much more straightforward and less sensitive. Some of the more significant COVID-19 related issues affecting companies include governmental policies over which the issuers likely have little or no control, for example, designation of products as essential versus non-essential, and second, the operational effects of social distancing policies or actual outbreaks of COVID-19. To name just a few examples, issuers in retail, travel, consumer goods, food service, or related industries, among others, may face particularly difficult disclosure questions in connection with securities offerings. On the other hand, issuers that already have a largely distributed workforce and do not rely on a large extent to physical production, manufacturing, and/or distribution of products may not face many impacts. With respect to the timing of the offering within the issuer's reporting cycle, the more time that has passed since an issuer last filed a 34 Act report, the more likely it is that the issuer will be aware of material developments that have not been disclosed. If the issuer is going to market just after it filed its Form 10Q, and the issuer did a good job of describing COVID-19 related trends and risks in that Form 10Q, then the process of reviewing this disclosure for purposes of the deal likely will be easy. Taking the other extreme, if the issuer is going to market during its blackout period at the end of the quarter and has not otherwise provided COVID-related updates during the quarter, for example, on a Form 8K, the focus on COVID-related diligence and disclosure will be much greater. In between those extremes, in the current operating environment, material issues can and have arisen for many issuers during the quarter. The more time that has passed since an issuer's most recent public disclosures, the more important it will be to look back at those disclosures and make sure they remain complete and correct. The quality of the issuer's disclosure in its most recent report also plays a role here. If the issuer did the bare minimum in terms of describing COVID-related trends and impacts, or if it just included generic or boilerplate descriptions, then its disclosure may become stale more quickly. Because the underwriters or initial purchasers in connection with the securities offering are exposed to potential liability for misstatements or material omissions in the issuer's disclosure under U.S. securities law, they and their counsel always perform an independent investigation of the issuer. The purpose of this investigation is to establish a due diligence defense in the case of an SEC-registered offering, or otherwise to demonstrate that they have not intentionally participated in a misleading offering in the context of a non-registered deal. Because COVID-19 and the related governmental policies can and have had sudden material effects on issuers, for example, if a major plan is required to close because of an outbreak, or if the issuer is otherwise suddenly prevented from selling a material portion of its products or services, the underwriters and their counsel will take a keen interest in the issuer's disclosure relating to the effect of COVID-19 pandemic. The underwriters and their counsel are likely to focus on recent results of operations, including within the current quarter. For example, an offering that takes place near the end of a quarter, the underwriters may want to know whether sales have slowed in recent weeks, or if there are other indications that the current quarter's or future quarter's results may differ materially from past results. In addition, if the issuer has published guidance and has not withdrawn that guidance, the underwriters and their counsel will want to know whether management still believes the issuer is on track to meet that guidance, what information management is basing its judgment on, and how much confidence management has in that raw data. For example, in past quarters, has the data available at this point in the reporting cycle been a good indicator of actual results? Management may face detailed questions and receive requests for documentary support. For example, underwriters and their counsel may ask to see internal sales reports or other internal reporting information. This next slide includes some examples of actual management due diligence questions which we have seen in connection with recent offerings. I will not read the questions in full, but these examples should give you an idea of the types of issues that underwriters are focusing on. You will also note that some of these questions align closely with the questions published by the SEC that Daniel discussed a moment ago. Overall, you can see that underwriters and their counsel are very focused on specific near-term financial and operational impacts that issuers are facing as a result of the pandemic. As I've discussed, when an issuer decides to go to the capital markets, it will be looking back at its most recent public disclosures to determine whether those disclosures remain sufficient for a securities offering, or whether it should include a recent development section or otherwise update its COVID-19 related disclosures. Now I will look in a bit more detail at some of the factors that an issuer may consider as part of this process. In this context, it's helpful to recall the two guiding principles of Rule 10b-5, i.e. no material misstatements or omissions, and the requirement to disclose known material trends or uncertainties. Some questions an issuer might ask itself include, how detailed was the disclosure included in the issuer's most recent SEC filing? What trends and risks has the company already highlighted? If the issuer has published guidance, where are the issuer's results trending in relation to that guidance? What facts have changed since the date of the issuer's last filing? How has management's thinking changed? I will run through a couple of quick examples that tie together the themes of those questions. A high level of detail in prior disclosure may be helpful if it means the company has already highlighted specific issues that have arisen at the time of a deal. For example, if the issuer has said that it expects governments in a handful of countries in which it sells its products to implement lockdown policies, which will have a material adverse effect on its revenues, cash flows, and net income, and those events subsequently take place, then the issuer's previous disclosure may well be adequate. On the other hand, if the issuer has previously disclosed specific expectations relating to the impact of the pandemic, and at the time of the deal, the issuer has information indicating that the previously disclosed information may not be correct, then the issuer may need to update its disclosure. For example, if the issuer has publicly disclosed that it expects to take a 10% hit to EBITDA and net income, but the information available at the time of a deal indicates that those numbers may be closer to 30% in reality, it will probably be necessary to update disclosure. Both for the liability reasons that I mentioned before and potentially for marketing reasons, The underwriters or initial purchasers and their counsel in connection with the deal likely will want to be very involved in thinking about and drafting these disclosures. If the issuer does decide to update its disclosure in connection with the deal, remember to consider Regulation FD, which prohibits companies from selectively disclosing material non-public information to analysts, institutional investors, and others without concurrently making widespread public disclosure. In recent weeks, a number of issuers that have disclosed material new information relating to COVID-19 impacts as part of the securities offering have filed an Item 701 8K. Also note that if the information disclosed includes material non-public information regarding the issuer's results of operations or financial condition for a completed quarter or annual fiscal period, such information should also be included under Item 201 on the Form 8K. The purpose of this final slide really is to dramatize the fact that material disclosure issues may arise even between pricing and closing a securities offering. An issuer should try to plan around that potential problem. This has always existed as a potential problem, but the risk is heightened in the current environment where unexpected material developments can and have occurred for many companies at almost any time. When thinking about disclosure in normal times, parties to a transaction tend to focus on disclosure at the time of pricing, which is, in general, the moment of truth when liability attaches under U.S. securities law. In addition, at the pricing time, the issuer will be giving representations as of the pricing time pursuant to the underwriting agreement or purchase agreement. Depending on what the issuer is disclosing and how the diligence process has played out, the CFO may also be certifying as to certain financial or other information as of the pricing time. However, in the current environment, it's also very important for the issuer to look ahead to the closing date and be sure it feels confident that its disclosures will remain complete and correct as of the closing date. The issuer's representations will be brought down as of the closing date. In addition, under a standard underwriting or purchase agreement, an executive officer of the company will be required to deliver an officer certificate, including a statement to the effect that the disclosure does not include any untrue statement of a material fact or omit to state a material fact necessary in order to make the statements made in light of the circumstances under which they were made not misleading. In addition, if a CFO certificate was delivered at the time of pricing, those certifications will also need to be brought down as of the closing date. All of these requirements will be conditions to closing of the offering. The risk that material developments may occur between pricing and closing was especially acute in the early days when the pandemic was becoming very serious, with travel bans, lockdowns, and social distancing just starting to be implemented. Major policy changes were being introduced literally day by day and in some cases hour by hour. Since that time, the U.S. economy has acclimated somewhat to these policies, and some policies are beginning to be phased out. So the risk of a material development occurring between pricing and closing may be less acute today than it was 1 or 2 months ago. Uncertainty remains, however, and we may find ourselves in those shoes again. So this issue is an important one to keep in mind in connection with your securities offerings going forward. Thank you very much.
Thank you, Barlow. Presenting next is Maria Sasanowski. Maria is a Securities and Capital Markets Associate in our Pittsburgh office. She focuses her practice on corporate law, including securities compliance, corporate finance, and capital markets, and mergers and acquisitions. Maria is going to be discussing annual meeting considerations due to COVID-19 and provide a summary of the SEC's COVID-19 filing relief. Maria?
Thanks very much, Jay. Hello to all, and thank you for joining today. I'd like to start first by discussing the SEC's order under the Exchange Act, which provides certain exemptions from the reporting and proxy requirements for public companies. And then I'll next touch on considerations for those companies who may be planning their annual meetings and the SEC staff guidance given on that topic to date. So first, let's take a look at the SEC's COVID-19 filing relief. On March 4th of this year, in light of the developing pandemic, the SEC issued an order recognizing that disruptions to transportation and limited access to facilities, support staff, and professional advisors as a result of COVID-19 could hamper the efforts of public companies and other persons with filing obligations from meeting their filing deadlines. And therefore, the SEC granted relief for certain filings made between March 1st and April 30th. On March 25th, as the ongoing public health crisis continued to unfold and the scope and magnitude became so large, the SEC issued a modifying order which superseded its earlier order and extended the relief to filings made between March 1st, 2020 and July 1st, 2020. The SEC's relief order applies to all registrants who are subject to the reporting requirements under the Exchange Act and any person required to make any filings with respect to such a registrant. The exempt filings include the Exchange Act periodic and current reports and all proxy and information statements. So this includes the 10Ks, 10Qs, 8Ks, 20Fs, 40Fs, and 6Ks, and as mentioned, also includes the proxy and information statements. Filings that are not covered under the order, i.e. Those filings that are not subject to relief, include Schedule 13Ds and amendments thereto, tender offer filings under Regulation 14D, Section 16 filings, and any Securities Act filing. In order to take advantage of the relief, registrants must satisfy several conditions. So there are four primary conditions that must be met in order for a registrant to rely on the SEC order. First, the registrant or the person required to make the filing must be unable to meet the normal filing deadline due to circumstances arising from COVID-19. Second, for each filing that is delayed, the registrant must file or have filed an 8K or 6K as applicable no later than either March 16th, 2020 or the original filing deadline of the report. That 8K or the 6K then needs to include 5 items. First, it needs to state that the registrant is relying on the March 25th order. Second, it needs to include a brief description of the reasons it could not make the filing on a timely basis. Third, it should include the estimated date by which the filing will be made. Fourth, it should include a company-specific risk factor or factors explaining the impact of COVID-19 on its business if it's a material impact. And fifth, if the delay is arising from some third party being unable to deliver its opinion, report, or certification, the 8K should include an exhibit with a statement by such person that states the specific reasons why that third party was unable to furnish that information prior to the required filing date. So that's the second condition, the 8K and the 6K. As a third condition, the filing must be made within 45 days of its original due date. And fourth, when filed, the filing must disclose that the filer is relying on the March 25th SEC order, and it should reiterate the reasons why it could not make the filing on a timely basis. It's important to note that the SEC's March 25th order functions separate and apart from Form 12b-25, which is a notification of late filing. The SEC has issued a few C and DIs on this topic and has specifically noted that a Form 12b-25 filing does not extend the original due date of a report. Therefore, unless a registrant has filed a Form 12b-25, also furnished that Form 8K by the original due date of the report, it would not be able to rely on the COVID-19 order. On the other hand, a registrant that relies on the COVID-19 order for the report will be considered to have a due date 45 days after the original filing deadline for the report. And at that point, the registrant would be permitted to subsequently rely on 12b-25 if it is unable to file the report on or before the extended due date. The SEC's March 25th order also granted relief in connection with rules regarding furnishing of proxy materials. The registrant is entitled to relief if it can show that the security holder has an address in an area where the common carrier has suspended delivery service of the type customarily used in making the solicitation or delivering the information. And secondly, where the registrant has made a good faith effort to furnish those materials under the applicable rules for the particular method, manner, or timeline of delivery as required under those rules. Let's turn now to other annual meeting considerations. The SEC staff has issued guidance for conducting shareholder meetings, which applies to both annual and special meetings. The staff guidance covers changes to the date, time, or location of shareholder meetings. What we're primarily seeing this proxy season are companies moving from an in-person meeting format to a virtual meeting format while still keeping the time and date of the meeting the same? For issuers who have already mailed or filed their definitive proxy materials, issuers may communicate any change in the time, date, or place, which includes a movement to a virtual format, by first issuing a press release announcing the change, second, filing the announcement as definitive additional soliciting material with the Commission, and third, taking all reasonable steps necessary to inform all of the other intermediaries, which includes the proxy service provider and other relevant market participants, such as the Securities Exchange, of the change. For those issuers who have not yet filed their materials, it's recommended that those issuers include a disclosure in their proxy regarding the possibility of changing the time, date, or location of the meeting due to COVID-19 concerns. Many companies with December fiscal year ends have completed or are in the process of holding their annual meetings this month, and these in this process handled quite consistently this season. So if your company typically holds its annual meeting later in the year, or if you have a special meeting coming up, you should be able to see some fairly consistent precedent out there now to help guide your disclosures. There are a few items to keep in mind if you determine that your company wants to switch to a virtual only or a hybrid meeting. First, you must ensure it's permitted by your state's law. Some states who previously did not permit virtual or hybrid meetings or had imposed significant hurdles or requirements to doing so have taken steps to temporarily suspend those restrictions in light of the current public health crisis. So you will need to determine if your company's state of incorporation permits you to hold a virtual meeting. Secondly, you'll need to review your company's governing documents. That includes the articles, the bylaws, and so on and so forth, and consider any restrictions on such a practice or specific notice requirements that must be met according to your governing documents. If you determine that your company is able to proceed with a virtual or hybrid meeting, then the SEC staff guidance simply states that the issuer must notify all parties involved of such plans in a timely manner. Importantly, you must provide clear instructions on the logistics of the virtual meeting, including how shareholders can remotely access, participate in, and vote at such meetings. These details can be included in the proxy statement, or if the proxy has already been filed, you would simply follow the steps described earlier to announce the change and provide the information. The SEC staff guidance addressed a few other matters. With regard to shareholder proposals, as you know, shareholder proponents are required to appear in person to present their proposals at the annual meeting. The SEC staff has stated that issuers should continue to strive to allow proponents to present. In addition, COVID-19 related issues will be deemed as, quote, good cause under the proxy rules to the extent that an issuer would seek to exclude the proposal from future meetings under the proxy rules. With regard to delays in printing and mailing of full sets of materials, the SEC staff recognizes that unavoidable delays could arise, and in which case the issuer is encouraged to use the notice-only delivery option. The key here is even if issuers are not able to meet every technical aspect of the rule, including the 40-day requirement, the issuer should provide shareholders with proxy materials sufficiently in advance of the meeting to review the materials and exercise their voting rights under state law in an informed manner, and so long as the issuer has followed the steps described earlier to announce the change in the delivery method of the materials. Issuers should also continue to use their best efforts to send paper copies of the proxy materials to requesting shareholders, even if such deliveries would be delayed. That summarizes my presentation. Thank you so much for your time and your attention.
Thank you, Maria. We're going to go back quickly to Rakesh, who will provide a quick poison pill update due to the financial market upheaval due to COVID-19. Rakesh?
Yeah, thanks. Just a quick overview. I put a few slides on a refresher on poison pills, which are basically defensive mechanisms designed to assist a board in a coercive or unfair takeover action. It essentially creates a almost insurmountable hurdle for an activist if the trigger threshold is met. So essentially, if an activist or another actor is trying to take over a company through a hostile takeover or unsolicited bid, a board can enact this poison pill, which essentially dilutes their ownership and provides rights to the other stockholders to purchase at a steeply discounted level, so that the potential acquirer is unable to. It's sort of cost prohibitive for that acquirer to move forward. So poison pills have been around for a long time, nearly 40 years. Today, they're really only adopted at the time of an imminent threat, so companies have them on the shelf, which means that they have drafts ready to go. And what we are finding is that particularly because stock prices are depressed now, companies that previously weren't takeover to candidates are worried that they might be. And so we're advising boards and companies to kind of look at the pill that's on the shelf and make sure that it's up to speed as to the current market environment and the current standards for poison pills. We're seeing a huge uptick in adoptions of poison pills, again, in relation to some specific threat, almost always, and including some large companies. And so what we're seeing by way of trends is that typically a 10-15% threshold is suitable. A lot of times the prevailing standard has been 15%, at least under Delaware, which tracks the interested stockholder combination statute. And then you have guidance advisory groups that look for things like 20% for the threshold. And now that we're seeing these specific threats come about, we are seeing the data show that the trigger threshold for when the pill would be activated is being lowered, at least in the normal traditional pill context, and which is separate from a net operating loss pill. And we won't get into some of those details, but at least as it relates to traditional pills, it does seem that there are more 10% thresholds than in the past. And as you go to a lower threshold, you start coming up with issues where if you have such a low threshold, well, you have normal non-activist passive investors, institutional funds that have over 10% of your stocks. You want to make sure you don't inadvertently trigger the pill simply by their ownership or accumulation of slightly more shares. So you have, we're starting to see more inclusions of grandfathering clauses and two-tier pills, which distinguish between active and passive investors. ISS generally and Glass Lewis generally recommends voting against directors who vote to adopt pills with a term of longer than 1 year without stockholder approval. Recently, both groups have confirmed that policy remains in place. They will review pills of 1 year or lower on a case-by-case basis, but they did state that they viewed the current pandemic as a genuine short-term potential threat, and so they will view any adoptions in light of that. So the takeaways are consider looking at your pill and seeing whether it has the appropriate features. Socialize the concept of the thresholds that are appropriate for your company. You won't have to make those decisions now while the pill is on the shelf, but socializing those issues when it's not in a crisis mode for your company in terms of a threat is usually the recommended best approach. Thank you.
Perfect, thanks. And our last presenter today is Lisa Taylor, based in our Jacksonville office. Lisa concentrates her practice on public company reporting and corporate governance matters. She'll be discussing the SEC she'll be discussing the review of the Main Street lending program.
Thanks, Jay. As Jay noted, I'm going to be talking about the Main Street lending program as well as special considerations for public companies that might become borrowers under it. The Main Street Lending Program is part of the CARES Act. The Federal Reserve first mentioned its intent to create the Main Street Program to facilitate loans to small and medium-sized businesses in a press release covering a number of matters issued on March 23rd. The Federal Reserve issued initial term sheets for the loans on April 9th, and then it issued revised term sheets plus frequently asked questions on April 30th. And these slides, the italicized aspects of them, indicate things that changed between the April 9th term sheet and the April 30th term sheet. This program is administered by the U.S. Department of Treasury and the Federal Reserve. It has aggregate funding of up to $600 billion. These loans, unlike the PPP loans, are not forgivable. And there are really three types of loans, which we'll talk about in more detail. There's the new loan program, the expanded loan program, and the priority loan program. So eligible borrowers can have up to 15,000 employees or $5 billion in 2019 annual revenue. The employee count is based on the average total number of employees for each pay period over the prior 12 months, and you should count all full-time, part-time, seasonal, or otherwise employed persons, but exclude volunteers and independent contractors. For revenue, it could be audited GAAP 2019 revenue or 2019 annual receipts reported to the IRS. Borrowers have to be organized in the U.S., have significant domestic operations, and a majority of employees in the U.S. They also need to have been established before March 13th this year. There are certain kinds of ineligible businesses under SBA regulations, and these are cross-referenced in the Fed term sheets. Some of these ineligible businesses include financial institutions and life insurance companies. Eligible lenders can be U.S. insured depository institutions, bank holding companies, savings and loans, U.S. branches of foreign banks, and intermediate holding companies of foreign banks. But there's no requirement that an eligible lender actually participate in offering a Main Street loan to their customer. There's a link to the frequently asked questions. It's likely the Fed will continue to refine the details of the program through FAQs and similar guidance before and even while the program is operational. As I noted previously, there are three kinds of loans, and the next couple of slides are going to talk about key terms specific to each loan type. The Main Street new loan facility can have a minimum principal amount of $500,000 and a maximum principal amount, which is the lesser of $25 million or 4 times EBITDA. It can be secured or unsecured. The government will purchase 95% of this loan. It has principal amortization for years 2 to 4 of 1/3 per year, and applies to loans after April 24th. The expanded loan facility can have minimum principal of $10 million and maximum principal of the lesser of one of these three things: $200 million, 35% of outstanding undrawn available pari passu debt equivalent, or 6 times EBITDA. Any collateral securing the loan will secure on a pro rata basis. 95% of the loan can be purchased by the government, and it amortizes in years 2 to 4 at 15% in year 2, 15% in year 3, and 70% in year 4. And the upsized tranche or revolving credit facility has to be originated before April 24th or with a remaining maturity of at least 18 months. That's the term loan that can be upsized through this. For the Main Street priority loan facility, which is a new one. It can have minimum principal of $500,000 and maximum principal of $25 million or 6 times EBITDA, whichever is less. It can likewise be secured and unsecured. Government will only purchase 85% of these loans, and it has the similar principal amortization of 15, and 70%. So key terms for all these loans is that a borrower can only participate in one kind, and the use of proceeds is a little bit restricted. It may not be used to refinance or repay existing debt. If it's repaid, it cannot repay other debt. There's a change between the two term sheets between April 30th and April 9th, and now that it doesn't require a borrower certification of financial need or evidence of negative COVID-19 effects. But it doesn't prohibit repaying of a line of credit, adding on or paying additional debt, and refinancing maturing debt, provided certain conditions are met. Other terms are that it has a 4-year maturity. The amortization payments are deferred for the first year. They have interest at LIBOR at the 1 or 3 month measurement. It was LIBOR plus 3% deferred for 1 year. There's no prepayment penalty. Lenders can decide how to determine any adjusted EBITDA. It doesn't restrict tax distributions on capital. Those kinds of distributions are permitted. And there are other relevant terms that you have to consider. These loans come with various covenants, including that you must make reasonable effort to maintain payroll and retain employees during the term of the loan, but that's just reasonable efforts. and you're not disqualified if you've already laid off or furloughed workers. Also, the compensation, stock repurchase, and capital distributions in the CARES Act, certain sections of CARES Act, apply under these loan programs, except, as we noted previously, tax distributions are permitted. So let's look at these covenant restrictions. Until 12 months after the loan is no longer outstanding, a borrower cannot repurchase any equity security listed on the National Securities Exchange of the eligible business or of any parent company, except those required by contractual obligation in effect on March 27th. They cannot pay dividends or other capital distributions with respect to the common stock, and we noted previously tax distributions are okay. It also imposes restrictions on employee compensation. Officers or employees whose total comp exceeds $425,000 in calendar year 2019 cannot receive total compensation over any 12-month period that exceeds their total comp in calendar year 2019, or severance pay that's greater than 2 times their total comp in 2019. Total comp includes salary, bonuses, awards of stock, and other financial benefits. There is an exception for employees with compensation determined through existing collective bargaining agreements. There's a cutback for employees who earn over $3 million in calendar year 2019. They cannot receive during any 12 consecutive months comp in excess of $3 million plus 50% of the amount over $3 million received in 2019. So these are pretty significant restrictions to consider. So when a company is thinking about borrowing under the lending program, these are some of the next steps that they might want to keep in mind, as well as some of the disclosure issues that have been previously noted by my colleagues. First, they might want to contact potential lenders about alternative loan terms rather than borrowing under this, and then compare these loan alternatives. Then evaluate whether the liquidity of this lending program outweighs the impact of the dividend, share repurchase, compensation restrictions, and other covenants imposed by the loan. They need to analyze their existing debt instruments to ensure compliance with the notice, consent, and covenant requirements in those if they decide to apply for the loan. And they may need to contact their existing lenders if waivers are necessary. Another step would be to identify employees whose compensation or executive agreements might be impacted by the limits. These might need to be amended. Then you'll need to analyze the financial impact and stock price impact of eliminating dividends and share repurchase programs for the duration of loan and for 12 months thereafter. And then if they are going to consider and recommend to the board that they obtain one of these loans, they would need to provide the board with thorough analysis sufficiently in advance of the board meeting to help demonstrate the board's exercise of due care under applicable state law in deciding whether to authorize the loan. If a public company does receive the loan, this needs to be properly disclosed, as well as the impact on the company's plans for dividends, share buybacks, and capital preservation. For example, they would need to update their Form 10-Q to include changes in the MD&A, risk factors, and subsequent event disclosures about the loan. The disclosure should also address the terms of the loan and these restrictions on dividends, share repurchases, liquidity, and executive comp programs. It's important to keep information about the company's plans restricted to a limited team because it's likely material inside information, and trading windows may need to be closed for these people if it is material until the information has been released. So that goes to the second step of disclosing the plans to borrow promptly. If you, for some reason, haven't already issued your proxy statement and you receive one of these loans, you might need to think about whether the compensation disclosure and analysis needs updating to the description of future executive compensation programs due to the restrictions. Due to the Federal Reserve's own disclosure obligations, borrowers should expect that the following information will be disclosed in any event: the names and identifying details of each participant in the facilities, the amount borrowed, interest rate, types and amounts of collateral, and overall costs and fees. At the end here are links to the term sheets that were issued on April 30th, and the frequently asked questions for more information. Thanks so much. I'll turn it back to you, Jay.
Thank you, Lisa, and to the entire panel for such great presentations today. In closing, as a reminder, if we didn't address your questions during the call, we'll follow up with you shortly via email. Feel free to contact us directly with any additional questions or comments. On behalf of our presenters and all of us at McGuire Woods, thank you for joining us today, and be safe. Thanks.